of the data on these devices? What was envisaged by the whistleblowers and by yourself?
The ultimate use was precisely what we are doing at the moment. The ultimate use of this evidence was to be able to make it available to a credible commission of inquiry in South Africa that would be able to use it in order to ascertain the veracity of the emails and all the other bits of evidence to assist this commission with its work in able to make appropriate recommendations so that the scourge of corruption in this country, in both the public sector and the private sector, could be addressed. That was the ultimate objective.
Right. Now, if you would look at paragraph 87, the last paragraph of your statement, you will see there in the second line that you use the words after consultation with Stan.
Yes.
You say it was furthermore agreed by everyone present at the meeting, and this is the Nairobi meeting, that the Commission would at a later stage, after consultation with Stan, attempt to undertake a successful recovery and forensic imaging of the original hard drive.
Yes.
In evidence now, you've used the words in consultation with. Are you aware of the rather formal approach that our courts have taken to the words in consultation with and after consultation with, and the formal distinction between them?
I am aware, and it was after consultation.
So let me, if I may, because in terms of the rules I must ask, before I may ask a leading question, Chair, did you understand that there was any understanding that Stan would have an ultimate veto on the fate of this hard drive?
No,
the original hard drive?
He would not. There would be a need to consult, but certainly there was no question of having a veto.
Mr. Curran, the statement that you have in front of you, or had in front of you, was amended in your writing.
Yes.
Would you look at this document? Do you have a copy in front of you?
I have a copy, yes.
Does your signature, well, whose signature appears on page 20 of that statement?
It's my signature on page 20. The handwriting of the amendments is your colleague's sitting right next to you. But I was with her when those corrections were made, and they were made after some discussions I had last night with people with whom I worked. This process has been going on, my engagement has been going on for a long time. Very often I did not take notes because I didn't want to record in a diary what I was doing, so I had to rely on memory, and my memory is not as good as it should be, so I think needed to make a few little corrections, which has been recorded on the document.
The contents of this signed statement, Exhibit J2, together with its handwritten corrections, are they true and correct?
They are true and correct.
May I have leave to hand up the duly amended statement?
Thank you.
Mr. Pretorius, there's one point that has not been covered. I don't know whether you've done, but this is one point that I want to mention.
Please feel free.
I mentioned, Mr. Chairman, that there was confusion about the clone which went to Nairobi, and that my commitment and our commitment had been to ensure that this commission got the best evidence, which would have been the clone of the original, and we'd ascertained that in fact what you had was not, probably not the clone of the original. In the meantime, previously, the original, well, a clone, the second clone, which we thought was the clone of the clone, was delivered, was given to me in Johannesburg at some stage before I travelled to Nairobi on that second occasion. When the clone in Nairobi appeared not to be the clone of the original, I made a commitment to, when I got back to South Africa, open the package that I got to check whether that clone was not actually the clone of the original hard drive. And when I opened it, the marking indicated very clearly to me that that was indeed the original clone, a clone of the original. And for that reason, I immediately contacted this commission and handed it over to this commission.
Also appropriately packaged and marked.
Also appropriately packaged and marked, so that that commitment of delivering the best evidence clone of the original was actually carried out.
Yes. That is interesting, Mr. Curran, and perhaps when the full story is told, will need to be told, but fortunately we know that despite expectations, the original hard drive was capable of being forensically imaged onto a further hard drive, which is the hard drive in respect of which relief is sought in this application.
Absolutely.
Is there anything further you wish to add?
I have nothing further to add, other than to thank this commission for the way in which they've worked with me. Thank you.
The statement is Exhibit J2, Chair, I'm reminded. Chair, Mr. Curran, the Chair may wish to ask you questions.
Oh, I'm sorry. Mr. Brian Curran's statement will be marked Exhibit J2.
Thank you, Chair.
Thank you, Mr. Pretorius.
That is the evidence.
Thank you. Just
there
one
are
question. Just one question to Mr. Curran. When you discovered that a certain clone was actually the clone of the original hard drive, at that time, was the commission already in possession of another clone that you had up to that point believed was a clone of the original hard drive?
Yes.
Yes. So you then took the clone that you discovered was the clone of the original hard drive and handed it over to the commission as well,
That is correct.
with the result that the commission is now in possession of both.
Correct.
Is that right? Okay, thank you. I wanted to have
Thank
that
you, sir.
clarified.
Thank you, Chair. Just to forewarn the Chair, there are two more tasks that must be completed apart from argument from Ms. Hofmeyr. The first is that the amended notice of motion must be handed up in accordance with the discussion that took place earlier. The second is that we would beg leave to hand over a sworn declaration in chambers after the conclusion of today's proceedings.
Yes, no, that's fine. Mr. Curran, I just want to take this opportunity. Of course, I have known you for a long time, from the 80s when you were National Director of Lawyers for Human Rights. Just want to take this opportunity to say thank you very much for the role that you have played in making sure that the Commission is able today to have access to this evidence that you have told us about. We appreciate it very much. The Commission will obviously still hear evidence in months to come, and will also hear, from what you have told us, evidence from Stan and John at the right time, and probably I will get an opportunity in the final report to say something about the role of people that played the kind of role that you have played in the end. But between now and then, there may be other evidence, and I don't know if there will be a challenge to your evidence or not, but we will hear what happens. But I just thought that it's important that I should let you know that this commission deeply appreciates the role that you have played to make sure that it has access to the evidence that it has been able to have access to. Thank you very much.
Thank you, sir.
You are excused.
Thank you.
Thank you, Chair.
Ms. Hofmeyer.
Chair, the good news is that there's very little for me to do because my learned leader, Mr. Pretorius, has dealt very extensively with the basis of the application, both at a factual and to some extent a legal level. There are, however, a few aspects of the legal approach to the application that is before you today that I would like to address with your leave. And I propose to do so in two parts. The first aspect will be to address the appropriate test.
Maybe before you go there, maybe let's start at the tail end. In terms of the prayer 1 and prayer 2, the prayer 1 and prayers 1 and 2 require me to admit the data referred to in the way described there. Is it the data that is sought to be admitted, or is it whatever it is where the data is contained? I don't know if you understand what I mean, but you know, you could have something, an object that contains certain information, and you might be admitting the object, that object, but inside that object there is certain information. So is it the information, the data, or is it the object that's being admitted at this stage that you want to be admitted that contains the information, so that the actual admission of the information, of the data, would happen much later when certain things have happened?
Chair, let me address that squarely. What Mr. Nombembe, as the applicant in this application, seeks from the Chair today is an admission principally of the data. And the data is the information contained on the 3 hard drives that are described in the notice of motion. And Chair, the reason for that is because of the manner in which that type of information is dealt with in our law. And the reference point for that is the Electronic Communications and Transactions Act. It is a statute number 25 of 2002, and it is the act to which reference is made in the application itself. What that statute makes clear is that there is something called data, which is defined by the statute to mean electronic representations of information in any form, and then in particular a data message, which is data generated, sent, received, or stored by electronic means, and includes voice, where voice is used in an automated transaction, and stored record.
You didn't make me a copy of the relevant statutes.
Indeed, Chair, we do have a bundle of authorities which I will refer to in a moment. Indeed,
I want to have a look at the definitions. I've seen section 15
yes.
of that act, which is quoted in this quick card, van der Merwe, the principles of evidence. But I would like to have a look at that as you speak.
Indeed, Chair.
If there is a copy available.
As I
would have appreciated it, receiving it yesterday.
Indeed, Chair. We do
Yeah.
apologise for that
Registrar,
delay.
please take
The Act is not contained in the bundle of authorities. The bundle of authorities that was prepared has the relevant case law.
Registrar, there is something that is ready for me there. Or is there not?
No, there is. Let me be clear.
Am I intruding?
Not at all, Chair, not at all. What the bundle of authorities contains is the case law to which reference will be made in the course of my argument. It does not have a copy of the text of the Act. We will endeavour to ensure that you have that as quickly as possible.
Oh, okay. Well, the case law I can look at later. I thought you might have the Act.
I've been informed by our attorney that efforts are being made to copy it for you immediately. So
Okay,
as
all
soon
right.
as it's available, I will beg leave to hand that up.
Yes, thank you.
Chair, if I may then just return to the question, because we are dealing with a series of technical aspects in today's application. The one is the data. As Chair, I understand it, for colloquial terms, we refer to it as the information that sits on the drives. And the manner of framing the notice of motion is to make it clear that it's that information which leave is sought to have admitted as evidence before this commission. And that is in keeping with the way in which electronic evidence is dealt with in the Act, to which I will make reference in due course. But Chair, while we're on the notice of motion, and I know we said we'd start at the end, might it be an appropriate time to beg leave to hand up the amended notice of motion, simply so we can address that aspect
Yes,
that you
thank you.
addressed with Mr. Pretorius?
Yes.
Thank you. Chair, what we've done since you received the original application and notice of motion is inserted on the second page a fourth paragraph, which seeks to address the issue you raised with Mr. Pretorius about public access, given the way in which prayers 1 and 2 and the ruling sought there is framed. So what has been introduced in paragraph 4 is a ruling that says as follows: notwithstanding the rulings in paragraph 1 and 2, those are the ones in terms of which the defined data is admitted as evidence. It goes on to say the public shall have access to that data defined as the HDDH data, the HDDH1 data, and the HDDH2 data, only as and when it is presented by the legal team of the Commission at the public hearings of the Commission.
Can we amend that a little bit?
Certainly, Chair.
Let us say the public shall not have access to that data until.
Yes, certainly.
So I'm going to delete only as and when and simply say until. Replace that with until it is presented by the legal team of the Commission at the public hearings of the Commission. Yeah.
Indeed.
Okay, thank you.
Thank you, Chair. And that actually also takes care of another aspect of the query that you posed to me, Chair, which is, well, isn't there a later stage at which this information is actually presented to the Commission? And that's precisely what paragraph 4 now, as amended, Chair, seeks to signify. And that is an aspect which was also traversed in the founding affidavit of Mr. Nombembe. The point that was made there is that it is critical for the work of the Commission that the data, the information on these 3 hard drives be admitted in evidence for, amongst other reasons, so that the Commission's investigators can analyze, synthesize, and pursue further investigations based on that information. It is then anticipated that pursuant to those investigations and possibly further authentication exercises that the investigators take on, those parts of the information, for example, relevant emails that are pertinent to the work of the Commission will be presented by the legal team through witnesses or to witnesses in the course of the future public hearings of this Commission. And so that is precisely the scheme that is envisaged by this application.
It wasn't clear to me when I read the affidavit why any analysis and investigation by the investigators needed the data to be admitted first. Why do they need that?
Chair, it is an aspect that we have probed in some detail with them, I can tell you. There is a bigger story that happens around this data, and I must deal with it now. This data plays a role, no doubt, and is critical to the work of this Commission. But this data may well also play a role in future possible criminal and civil proceedings. And it is with a view to its further use in those proceedings that the investigators of this Commission are very careful to ensure that any work that they do on forensic images of the original data is secured in its integrity by a moment in time, which is this application before you today, to recognize the steps that have been taken until this point to secure the recovery of the original and to make that data available to the Commission. And it therefore seeks the comfort of knowing that if at this moment in the Commission's proceedings this ruling is made, it will then comfortably, off the back of that full chain of custody, having been presented before this Commission, be able to work with that data, to analyze it, to rearrange it, to strip it out, to reconfigure
But why do they need an order admitting the data to do that?
Chair, it is an aspect of why it is being sought today. Your crisp question is, why do the investigators want this admission in order to be able to deal with the data? And the explanation is contained at paragraph 64 of the application, if I may just direct you to it. You will see at paragraph 64, the point is made that until this point, the Commission's investigators have been careful to analyze only the HDDA data. Now, let me just be clear about what that is. That's the data that was originally...
That's the original hard drive.
And the data from it that found its way into the Gupta leaks, right. And it is off the basis of the analyses that they've done of that data that they have been able in this affidavit to make some initial claims about the authenticity of the data. But it is essential for the purposes of this Commission and for future work that might require this information to be relevant, that the actual recovered and what we understand to be fuller set of data is analyzed for authenticity. The Commission's investigators have not done that yet.
That I understand. What I don't understand is the hard drive and the clones are in the possession of the Commission. The investigators are part of the Commission. They carry out investigative work for the Commission. I don't understand why, without an order admitting the data in these proceedings, they can't do what they need to do to pursue the work of the Commission in terms of investigation.
Chair, we would not put it as high as they can't. Certainly not.
Or if it's not a matter of they can't, or what the reason is, why do they need that order?
Indeed, Chair. And that requires me to go to the further reasons for why this application is brought now. Because as your question highlights, Chair, and we should not be heard to say they can't deal with the data without this order. That is certainly not the case. It is appropriate, rather, that this ruling be given now, and that requires further considerations to be taken into account. So to recap, the one is that the investigators who are concerned with the integrity of the chain of custody process would like to be dealing with HDDH1 data and HDDH2 data with the confirmation from this Commission that it is admitted in evidence. But I don't put it higher than that is a request of theirs. It's not a prerequisite for them dealing with it. The second important point is where we are in these proceedings and the availability of Mr. Curran, who has come to give evidence today, and the appropriate point at which this disclosure could be made, albeit on its limited terms because of the safety issues of those concerned. And secondly, thirdly, indeed, Chair, an important aspect that is traversed in the application is that in parallel with this application before you, which has taken place in public, there is a full chain of custody set of documents that is being compiled by the Commission, which has detailed confirmations of every step that was taken to ensure the integrity of the drives, to ensure that parcels were tamper-proof, to keep records of every register of evidence being received and being taken to its next location. It was in the view of the Commission, its legal team and its investigators that it was critically important to freeze this moment in time when all of that evidence could be put together, albeit not yet publicly disclosed, so that if anything were to happen to individuals involved in that process, there would nonetheless be a credible source of that information which may become later relevant in criminal or civil proceedings. So it's a confluence of those three factors, Chair, that brings this application to you today.
Well, the last point, does it amount to this, that for, among others, reasons of the preservation of the evidence as it exists at the moment where it is kept, it was important that it be publicly known
Indeed, Chair.
that the Commission has this kind of evidence which has been obtained in the manner in which we have been told, albeit not in full for certain reasons, so that going forward, if anything should happen, at least it should be known what evidence the Commission had as at a certain date.
Indeed, Chair. That is precisely the third consideration. And it is flagged, just for your reference, at paragraph 76, which is on page 27 of the application. It says there, and I read from Mr. Nombembe's affidavit, it is also in the public interest that the integrity of the process that has been followed thus far by the Commission's investigators and legal team be recorded. If anything were to happen, it is important that the Commission has a record of the chain of custody in order for this to provide a basis for the possible admission of the data in future. And Chair, if I may say, the further point, as I understand your question to me, that is added, is it's about preserving that which is now in the possession of the Commission and with knowledge publicly that the Commission is in possession of that important evidence for the conduct of its further inquiries. Thank you,
Yes,
Chair.
okay, thank you.
Chair, so we were on the aspects of the, amended notice of motion that were addressed. And I've usefully been just handed a copy of the Electronic Communication and Transactions Act, if I may beg
Thank you.
leave to hand that
Yes.
up.
Thank you.
Chair, it might be an appropriate point just to summarize the points that I was making in relation to that act now that you have a copy available to you. Chair, I was dealing first, you would have seen reference, as you mentioned, in the evidence textbooks about particularly Section 15, because Section
Yes.
15 deals with admissibility and evidential weight of data messages. Where I'd begun was with the definitions of those terms in the Act. And data message is, of course, a derivation of data. And so we start with data, which is the language used in the notice of motion. Data means electronic representations of information in any form. And then the data message becomes more specific. It means data generated, sent, received, or stored by electronic means, and includes voice, where voice is used in an automated transaction, or a stored record. We're really in the context of B, a stored record for the majority of the information that we're talking about here. And then what Section 15 does is it talks about the requirements for admissibility, but I must emphasize, in legal proceedings for the receipt of data messages, which generally in the literature is referred to as electronic evidence. But Chair, before we get into the detail of Section 15, it is important that I frame the test appropriately, which is the one that this Commission we submit will adopt when determining whether to grant this application. Chair, and that requires me to emphasize again, as my learned leader, Mr. Pretorius, did, that a commission of inquiry is a species different to a court of law. Chair, this is recognized around the world, and it has been well expressed with respect by a number of the highest courts in various jurisdictions.
All right, well, there you have it. That's the state capture inquiry currently taking place here in Johannesburg. We'll let you know a little bit later on here on the program as to what transpired today. Of course, the commission still continuing. But for now, let's take a look at your headlines. The legal team at the Commission of Inquiry into State Capture says it is highly improbable that the so-called Gupta Leaks emails are fake. Family members, colleagues, friends and members of the community in general have gathered to celebrate the life of the late Environmental Affairs Minister, Mam Edna Molewa. And in sports news, Cheslin Kolbe and Skhumbuzo Noche will make their first appearances for the Springboks when they take on Australia in the Rugby Championship Test in Port Elizabeth this Saturday. Good afternoon to you. Thank you so much indeed for joining the team on SA Today. My name is Balesa Chubisi. Let us now take a look at your top stories for this hour. The legal team at the Commission of Inquiry into State Capture submitted an application requesting 3 hard drives containing data known as the Gupta Leaks to be made part of the evidence by the Commission's next witness. The Commission also heard testimony of lawyer Brian Karen, who shed more light on the Gupta leaked emails, which made headlines last year implicating public officials and the controversial Gupta family. The application has been brought forward by the head of investigations, Terence Nombembe. Legal head advocate Paul Pretorius says all 3 hard drives are currently in the possession of the Commission for safekeeping.
To clarify once again, HDDH is in safekeeping.
Yeah.
It will not be worked on, but it is always there as evidence. HDDH1 and HDDH2 will be, if the application is successful, worked on by the investigators and analyzed accordingly.
And HDD A is the original hard drive.
Is the original hard drive. If that is accessed in an investigation process, the chances of it being entirely damaged, irrevocably damaged, are too high to allow that to happen. So that is in safekeeping under the control of the Commission. But that is the original.
It can only be worked on or touched, as it were, by a relevant expert.
Correct.
If it is not to be damaged.
Correct.
Okay.
But the expert will have told you that HDDH is an accurate and virtually complete, and when we say virtually complete, the figure I will refer you to in a moment is 99.9999%. So that's not bad, Chair.
The Democratic Alliance leader, Musi Maimane, wants several senior members of the ANC who have been implicated in state capture so far to appear before the inquiry. Maimane was leading a picket outside the venue of the commission. The DA has already written to the Secretary of the Commission requesting that 12 ANC witnesses appear before the Commission and explain their alleged role in state capture.
We are trying to add support to Judge Zondo to say, don't just stop here. There are many people. And ultimately, how do we make sure as a society that state capture never happens again? This commission is investigating what is happening at state-owned enterprises. Remember, state capture also happens at municipalities. Municipalities are being captured, money is being stolen, and ultimately we want to rid South Africa of this concept, ultimately. So we are here to make it quite clear. I want the ANC and its leadership to come and stand here. As the banks have testified, so must the ANC.
The Constitutional Court has ruled that the NPA must look into whether former Social Development Minister Bathabile Dlamini should be prosecuted for perjury. The court says the Ngwebe inquiry into the payment of social grants by Cash Paymaster Services found that Dlamini had misled them in an attempt to avoid paying legal costs. The court has also ruled that she is personally liable for 20% of the legal costs in the case linked to the Social Security Agency grants debacle. Justice Johan Froneman delivered the unanimous judgment earlier.
Minister Dlamini misled the court to protect herself from the consequences of her behavior. She allowed a parallel process to occur knowing that she withheld information that might lead to her being held personally responsible for the social grants disaster. In relation to the reason why Minister Dlamini did not disclose to this court that the individuals were appointed at her in the parallel inquiry and that they had to report directly to her, the inquiry report was diplomatic but nevertheless damning. In essence, it found that Minister Dlamini had failed to make full disclosure to this court. The inquiry's report that the minister's failure to disclose this information was her fear of being joined in her personal capacity and being mulcted personally in cost has not been and cannot be faulted. The inference that she did not act in good faith in doing so is irresistible. At best for her, her conduct was reckless and grossly
in the relevant statutes, relevant to the mandate of this commission. And we submit that that must be unquestionably so. Mr. Pretorius has already dealt, Chair, with the links to the terms of reference which were traversed in the application itself. There are, on my count, at least 6 terms of reference that speak specifically to the engagements with the public sphere in our country and the Gupta family. You will have heard from the evidence of Mr. Curran, and it's also referenced in Mr. Nombembe's affidavit, that what this data appears to show is communications between members of the Gupta family and associates with individuals such as Mr. Duduzane Zuma, various cabinet ministers, officials and chief executive officers of state-owned enterprises. We submit that there can be no doubt that it is relevant to the terms of the reference of this commission that this information be further investigated. Chair, there's a further point to relevance. And we submit that admitting this data now is consistent with the truth-seeking pursuit of this inquiry. And the reason for that is the following. You heard earlier this morning that the recovery exercise that was managed with the employment of a leading international expert on recovery is such that the version of the data which is currently held by the Commission is likely to be greater than the data that found its way into the Gupta leaks. Those are the initial indications that we received, both from what Mr. Curran told us about how that original data entered the public domain and what you know of the process that was followed by the Commission in securing this expert to do a 99.99 something% recovery, and to confirm that he is satisfied that that recovery was indeed effective, and that we have, for all intents and purposes, a virtual replica of the original data. Chair, there's an overwhelming public interest, we submit, in the Commission's investigators being in a position to analyse that further data, and where appropriate for it to be presented to this Commission in its public hearings. If only part of the story that can be gleaned from that data has been told thus far, the whole story must be told through the proceedings of this Commission. And it is for that reason that we submit it is critically important for the Commission and its expert investigators to begin work on that data so that it can be presented in due course. Chair, the second aspect of my submissions ventures beyond what we say is really the simple question before this Commission. Is the data relevant? And if so, it should be admitted, and the process of its analysis and presentation should then be followed. But the application does go further than that, Chair. It goes further to deal with the aspects of reliability that is already apparent in this data, and it addresses questions of confidentiality that could be raised in due course, and the steps that have been taken to protect any possible interests on the part of Sahara computers that may be raised in due course. And so, Chair, with your leave, I'd like to deal very briefly with those two aspects.
Yeah.
Chair, the reliability aspect has been addressed for a range of reasons in the application. The first is with a view down the line to the use that might be made of this data in criminal and civil proceedings. I've already addressed to you, Chair, the careful steps that have been taken by the investigators and the legal team of this Commission to ensure the integrity and to preserve the integrity of the drives on which this data sits, and on the authenticity processing of that data, so that its credibility and its integrity can be presented in due course. This has been done not only with a view to those future proceedings, but also because of the only public statement that we are aware of that has yet been made by those persons who appear to be implicated by the information on the drive. And that is the reference that my learned leader, Mr. Pretorius, made to the public statement of Mr. Gupta that these emails were fakes. Well, it's as against that charge that some initial work has been done to assess the reliability of this data. And that is set out in detail in the application. The essence of the point is that it is in all probability highly unlikely, necessarily incredible, that this massive amount of data, with its both visible and hidden traces within the drives, could have been manufactured, or manufactured in a manner that makes it work as such a cohesive whole on the drive itself. So that is the first aspect of reliability. The second aspect of reliability is the emphasis that will be placed on the declaration of the international expert who has worked on this drive and done its recovery, That will be presented to you in camera, but the essence of that evidence is the expert's both qualification as an expert and confirmation that he achieved a 99.99986% recovery. And so that itself should give the Commission great comfort on the question of whether what it will be presented with is a replica of that which sat on the original drive. It's a separate question whether that which sat on the original drive was manufactured, but I've already addressed you on all the hallmarks of authenticity that appear to lie already in that data. Chair, the second point is confidentiality. There is sometimes a tussle in our law between the disclosure of information that may implicate the privacy interests of a party as compared with the need for the public to know the content of the information. And Chair, the application traverses the relevant case law in that respect. I would highlight for present purposes only a few. Our courts have already determined that the public interest may outweigh, and it's an example, but national security interests where those were claimed for top secret and classified material in the independent newspapers matter that came before the Constitutional Court. Our courts have also determined, as Mr. Pretorius highlighted earlier, that the private medical records of a former Minister of Health could be disclosed in the public, notwithstanding the fact that they were unlawfully obtained. And our courts have also determined that even a privileged legal opinion of South African Airways could be disclosed publicly because of the manifest public interest in understanding and learning what was going on within that institution at the relevant point in time. And so, Chair, we submit to you today that if in due course any attempt is made to raise the spectre of confidentiality as a basis for this Commission not to deal with this information, we submit that contention should be rejected, and it should be rejected because of the overwhelming public interest in a proper investigation of these matters, because of the terms of reference with which this Commission has been charged. Chair, the final aspect is to facilitate any representations that Sahara Computers may wish to make in due course, and the notice of motion seeks as its third prayer a ruling that will facilitate notice being given and an opportunity, if it is taken up, to make representations to you, Chair, about the admission of this data. Chair, those are our submissions in support of the application, unless there are further questions.
One has got to always remember that one is not in a court of law.
Indeed.
And therefore, from time to time, try and not act in a manner that a court would necessarily act or decide. But of course, it doesn't mean that one must discard everything that courts of law do. Normally, when a document or real evidence is being admitted in proceedings, that's placed before the court. We are now talking about a court of law. That's handed up and so on. This is not happening here. But one advantage of a document, for example, being handed up is that I could have a look at it, at the contents, and maybe get an idea that it could be relevant. But if it's not put up, I may have to rely on somebody to tell me if it's relevant. And maybe that might not be the final word as to whether it's relevant or not. Now, to the extent that the order admitting the data is an order admitting, as the Act says in terms of defining what data is, I think representations, it says, data means electronic representations of information in any form. As I understand the position, and remember I've got to decide things based on, not on what I may be reading in the media, on what I have here. Based on that, or based on what I've read in Mr. Nombembe's affidavit, there are hundreds of thousands of emails. The affidavit, from what I read in the affidavit, it would seem that somebody or people must still go through those and be able to say these are relevant, these are not relevant. I don't know out of, if the figure is 300,000, which was mentioned, I think, somewhere. I don't know whether that might mean, for example, 50,000 are relevant, or only 100 are relevant, or 50 out of 300,000 are relevant. So how do I make an order admitting all of them if I don't know that all of them are relevant? Because even on your own address, at least whatever I admit whatever I admit must be relevant. Now, if I don't know whether they are all relevant, how do I do that?
Chair, I'd like to, in answer, draw a distinction between its admission and the role that it plays in informing your ultimate recommendations in the pursuit of this inquiry. Because all that is being sought today is admission in evidence for the purposes of analysis and later presentation to you in the conduct of this inquiry. I accept that there must be a measure of evidence, a measure of relevance already in the data, and that is what the application seeks to traverse. It contains a detailed analysis that has been done by the Commission's investigators on the HDDA data, so that portion of the data that found its way through the Gupta leaks into the public domain. And that is squarely relevant to the terms of reference of this commission. What we've signaled to you today is that there may well be more, and there is likely to be more, in the data that was recovered by the international expert. But in its substance, the overwhelming majority of that which has found its way into the public domain is relevant. You would simply be admitting it today for the purposes of these processes to be completed by the Commission, and in due course, those relevant emails will be presented to you through the evidence leaders and further witnesses, and you will ultimately make a decision as to first the weight to be attached to them, dependent on whether there are any challenges, and then secondly the role they play in your ultimate recommendations.
Yeah, no, the weight is obviously something else that's for much later. But you yourself say, for purposes of me making a decision whether I admit HDDH data and HDDH1, HDDH12 data, it must be shown that it is relevant.
Yes.
And my question is, how do I know, and again I leave out what I may or may not have read outside, how do I know on what is before me? How do I know that all that you are asking me to admit is relevant?
Chair,
And this may be raising or bringing back the question I asked earlier on. Let's go back to a court of law, and it's useful to always go back to what we are all used to. In a civil case or in a criminal case, there would have been an analysis of documents such as these first before they are brought to court, to a trial. So when a request is made for them to be admitted, it would be made on the basis of there having already been an analysis and a view taken on the relevance of each one of them. And obviously those that were not seen as relevant would not be sought to be admitted. That's how it would work in a court of law.
Indeed.
Okay. Now here, easily that could happen with this commission as well. The investigators could, or whatever experts could analyze, go through the mountains of paper or just looking at them electronically and select those that are relevant and leave out those that are not relevant, and then bring those to the legal team of the commission and say, we have gone through all this data and we are now giving you what in our view is relevant. We have left out what is not relevant. And then the legal team could then come to the commission, to the hearing, and say, these are the ones we ask to be admitted. They have been sifted. You see what I mean? They have been sifted, but we are now in a situation where they have not been sifted yet, and I'm being asked to admit all of them.
yes, because, Chair, you are absolutely correct with respect that the full extent of the HDDH data has not been analysed. But what the application makes plain is that the HDDA data, that which is already in the public domain, has been analysed. And its relevance to the terms of reference of this commission is set out in detail. If I can just take you to paragraph 55 of the paragraph 55 at paginated page 16 of the application. This is the evidence before you today.
Yes.
It is exhibit J1, which is Mr. Nombembe's affidavit.
Yeah.
And under the topic of relevance, this section of the affidavit begins with the following. There can be no doubt that the HDDA data, and by inference the HDDH data, because remember H is bigger than A, and so will necessarily include A for the purposes of this debate, is relevant to the terms of reference. This is clear from the following. This is what Mr. Nombembe says on the basis of the work that has been done by his investigators on HDDA.
Okay.
He says it contains communications and other information relating to the affairs of the Gupta family and their association with government officials and state-owned enterprises. And then he goes on to tell you how those aspects relate to the terms of reference. And so there has been an analysis done of that which is already in the public domain, and there is evidence before you today of its relevance. But steps have been taken by the Commission to get a fuller recovery of the original information, which is greater than the A data and which must still be analysed and must still, in due course, be presented to this Commission at its public hearings. And so we would submit that there is already an overwhelming case for relevance.
I'm sorry, the one that has already been analyzed,
Yes.
Is it the original?
It is the, let me be clear here, the original
That is A.
A
Yeah.
was cloned, and that data was made available to Daily Maverick
Yeah.
and to Amabungani,
Yes.
and found its way into the public domain through the articles of their journalists and others.
Yes.
That is what we refer to as the HDDA data.
Okay.
That has
that's
been
in
analyzed.
Prayer number 1.
Indeed.
Yes.
Well, no, sorry. Prayer number 1 does not refer to H data. It refers to H data, not A data. The analysis that has been done is on A data, which is a component of the H data. Let me just be clear. The A data is what entered the public domain through the Gupta leaks. The H data is that larger set of data that was recovered by the international expert working in August of this year, and which is now in the possession of the Commission. The Commission seeks admission of the H data because it is the fullest set of data that was recovered from the original and forensic imaged onto the H disk drives. But for the purposes of the relevance question that you raised, Chair, what you have on the affidavit of Mr. Nombembe is the analysis that has been done of the A data, which is a component of the H data, which itself is clearly relevant to the terms of reference of this Commission. So, as I understand the question you posed to me, Chair, it is what confidence can you have today of the relevance of the data that you're being asked to admit to the terms of reference of this Commission? And we submit you can be overwhelmingly confident about its relevance because the A data, which is a component of the H data, has already found its way into the public domain and has shown that it deals with the affairs of the Gupta family, their association with government officials and state-owned enterprises. Chair, the application even gives you some examples, and let me just take you to them, because some of them are critical for this question that you've raised. And they are attached in various annexures, various articles that arose with the Gupta leaks. Let me just find the reference, if I may. If you go to paginated page 26, you will see that some of the information that has made its way into the public domain because the HDDA data was provided to the journalists at Amabungani and Daily Maverick is the following. They show that the Bell Pottinger proposed press release during March 2016 that would have implicated Deputy Finance Minister Mcebisi Jonas in receiving bribes from a South African businessman. They show how 2 months before the former president, Mr. Jacob Zuma, appointed Mr. Mosebenzi Zwane as Mineral Resources Minister, his curriculum vitae was sent to the Gupta family for their attention. It shows how Minister Faith Mutambi exchanged proposed drafts of a presidential proclamation with associates of the Gupta family before the proclamation was promulgated. Those are illustrative examples for the purposes of this application to answer squarely the question of relevance.
Those would fall under the component that has been analyzed.
Indeed.
Yes.
Indeed, Chair. And it is a portion of the greater recovered data that was the product of the international experts' efforts in August. So what we are able to say to you today, Chair, is that a component of the H data, which has been in the public domain, shows that this full data set is clearly relevant to the terms of reference of this Commission, because it is, in the main, email communications between associates of the Gupta family, cabinet ministers, heads of SOEs, and their dealings. And there may be more that is relevant. But that which we already have and have been able to analyze, we know is relevant.
You see, what there can be no doubt about is that part that has not been analyzed. It's important that it be analyzed.
Indeed.
There can be no doubt about that.
Yes.
Now, the investigators would do that, okay? But again, I think I come back to the question, why, let's separate the two, that part that has been analyzed. That is relevant, let's assume, is established, therefore maybe can be admitted. The part that has not been analyzed, because it hasn't been analyzed, we can't know, can we, for sure whether it is relevant. But once it is examined and analyzed, its relevance or otherwise will be established. Now, why, to the extent that I should make any order of admission, why shouldn't I admit what has been analyzed, because its relevance might be established, but in regard to what has not been analyzed, I make no order that doesn't prevent the investigators from analyzing it, and at the relevant time that can be raised here in the commission after somebody has been able to take a view of its relevance.
Chair, you posed the question on the basis that we couldn't know for certain what was in the remainder. I have to concede that. But we know with a very high probability what is in the remainder. And that is because of the nature of the data messages that these drives contain. And that is set out in Mr. Nombembe's affidavit. They are, by and large, in the majority, email communications. And the background, hidden messaging that happens pursuant to that communication, and some other information. Now, because we have seen parts of that through the A data, and in the majority it appears to be relevant, well, is relevant on the basis of what has been publicly disclosed already, there is an incredibly high probability that the remainder is. I can't say for certain, very few things are certain, but a very high probability.
But how does the work of the commission get prejudiced if I don't make an order admitting that part, that component? How does the work of the commission gets prejudiced?
Chair, that takes us back to the previous debate we had about why now. And it's to signify that there's more in this application than merely the need for analysis to take place and emails and other evidence to be presented. It's that at this very moment, the Commission has within its possession the fullest recovery of the data from an original hard disk drive that came from Sahara Computers. And it is because it has that in its possession, and it was appropriate for that to be publicly disclosed now and could not be disclosed previously, that this is a moment in time in which it should be admitted to preserve that full record which is now in the possession of the Commission.
But where it is sitting now, it is preserved. That's what the witness told us.
Yes.
It's secure, it's preserved. Only very few people know about it. Why is an order admitting it necessary for its preservation?
Because despite all the endeavors that have been made to secure it, something may happen to it. It is within the borders of South Africa, HDDH, albeit in a secure location. That has been disclosed in the affidavit before you. It is appropriate that all precautions be taken by the legal team and the investigators who are the custodians of that resource of data. Tell us publicly that they have it, and having done so, increase the preservation of it.
Well, what is the meaning of an order admitting piece of evidence? I don't think that the mere making of an order that a court or a forum such as this is admitting a certain piece of evidence on its own helps anything with the preservation. Obviously, normally what would happen is that that piece of evidence is handed up, and then the registrar in the case of a court preserves it, whatever. But here we have a situation where we have been told that all that evidence is somewhere secure, and all precautions have been taken to make sure that it is safe. Obviously, maybe I shouldn't say obviously, there are no guarantees in life, but from what I've heard, for all intents and purposes, everything has been done to keep it safe, and I want it to be safe. I'm just not sure that I follow why an order of admitting it is necessary for its preservation. With regard to evidence that has been analyzed, at least its relevance may be clearer. And the evidence that has not been analyzed, probably some of it is relevant, maybe some of it is not relevant, and I'm just saying, how does it help anybody for me to make an order saying I'm admitting that part of the evidence? How does it prejudice the work of the commission? How does it prejudice the work of the investigators to make or not to make that order? What I referred to earlier on about publicly saying what is in the possession of the commission, we have already been saying, the witness has told South Africa through these proceedings are being broadcast, so people who have an interest in what the commission is doing will know what we have already in terms of that evidence. I'm just not sure of the necessity of making that order now, at least in regard to that. It may be that it may be that it's something that maybe the legal team might wish to reflect further on, and I'm quite happy that we look at it before any decision is made. But I have that concern as to I can see that I may make an order admitting the part that has been analyzed. I'm not so sure about the part that has not been analyzed.
Chair, thank you for that. If we may take you up on that opportunity, we're close to the conclusion of today's proceedings, and we do want to reflect carefully on the issue that you've raised and how it may affect the rulings that are sought in this application. So if it would be appropriate, and with your leave, possibly to take a moment and adjourn to tomorrow morning. I don't know what's most suitable to you, Chair.
No, that's fine. We can adjourn to tomorrow morning at 10, and then we can look at it. It may well be that you might persuade me, but I just have those concerns. And I mean, there is no doubt that the investigators should go ahead and analyze the component that has not been analyzed. There's no doubt about that. But I say they don't need an order admitting that those components as evidence in order for them to do that. And then I just ask why we need to do that, to make such an order in regard to that component in circumstances where, with regard to its relevance, we say it hasn't been analyzed, so some of it may be relevant, some of it might not be relevant, maybe most of it will be relevant, but do we need to decide now, or should we let the process of analyzing take place first, and then a view is taken, and once a view is taken, what is brought up for admission is only that which is established as relevant. Okay.
Thank you, Chair. We will
Okay.
give careful consideration to those aspects.
Okay, all right. Thank you very much. In terms of arrangements for tomorrow, will it be that part? We don't have any witness for tomorrow, is that right?
No.
Okay. And as things stand, the witness for the 3rd of October, arrangements are still in place for that.
Yes.
Thank you. The proceedings adjourned for today will resume tomorrow at 10.
Se for pensar em tudo que está ao redor, é tanto amor, é como um mar. Abre os olhos, vejo o mar que está dentro de nós. Vai, fecha os olhos, solta a voz.